Hello, my name is Robin Happel. I'm an environmental law student currently in a joint JD program between Yale and Pace Universities. Just as a quick disclaimer, everything you'll see in this presentation today is not formal legal advice. It does not create an attorney-client relationship, and it is purely for general informational purposes. So if you're interested in energy environmental law in your jurisdiction, I would encourage you to reach out to a local attorney who is barred. I am currently a law student. My climate law professor looked over this, so it is legitimate factual information as far as I know, but always consult with a barred attorney in your jurisdiction if you're interested in this. I promise we don't bite hard. Okay. Couldn't resist that. So without further ado, this is climate law. So I originally created this slide deck for a virtual youth town hall with UNA. I'm currently a Global Goals Ambassador for Climate Action with the UN Association. So basically what that means is with my co-ambassador Jasmine, we've been promoting Sustainable Development Goal 13, which is basically climate action to further other UN global goals, and also human rights and the environment more broadly. And I'm also a climate reality leader. And so this was a nice kind of coinciding with 24 Hours of Reality earlier this fall. And again, disclaimer, I'm a law student, not a barred attorney, and this is not formal legal advice. But the background is very sparkly. I'd like to begin with this plaque, which was from a glacier that actually had a formal funeral. And this really stood out to me because it was the August as I was starting 1L. And just to read this quickly in case it isn't showing up for you, the title on the plaque is A Letter to the Future. Ok is the first Icelandic glacier to lose its status as a glacier. In the next 200 years, all our glaciers are expected to follow the same path. This monument is to acknowledge that we know what is happening and what needs to be done. Only you will know if we did it. August 2019, 415 parts per million CO2. That's closer to, I believe, 418 now. So clearly we have not reversed trajectory as much as we need to. And what really stands out to me about this is we know what is happening and what needs to be done. So much of what climate law seeks to do is further existing scientific knowledge. So although we will be touching a little bit on research in parts of this presentation, this really isn't climate science. It's more applying the science that has already been done. Additionally, I should say I'm focusing primarily on climate litigation. If you're interested in the UNFCCC and the Paris Agreement and all these other wonderful frameworks the UN has come up with, there's a bunch of free resources on a site called Informia, which is run by UNITAR and the UN Environment Program. So if you look up Informia, they have a bunch of really great free resources on climate law. Essentially, the UNFCCC, the UN Framework Convention on Climate Change, came about in the early 90s, and it's really a framework convention that set the stage for the Paris Agreement and other future climate agreements. And although Paris has been in the news a lot lately, justifiably, with the US withdrawing and then pledging to re-enter, it's not necessarily the only vehicle for climate law we should be concerned about. So I don't want to not mention the Paris Agreement, but I think it's also important to focus on litigation and what we as citizens can do on the local level. So one of my very great mentors during law school so far has been Tony Aposa, and he's currently leading an action to try to bring a youth climate case to the ICJ. So this is fairly difficult procedurally, but in his home country, the Philippines, he's had a lot of success domestically combating old growth logging. And he's really famous for a case called Miners Aposa v. Factorin, which set the stage for Juliana v. US, and recently the Agenda case in Europe, and so many other youth climate cases around the world. And so this is sort of his philosophy behind climate litigation. So essentially, the beauty of a legal action is it lights a star. If you tell a story in a court of law, people begin to listen. So this really parallels the way that civil rights law and other areas of human rights law have been used to bolster social movements. So essentially, we're saying like climate activists outside the courtroom have been demanding so much change that the legal system needs to keep up, and we need to help support activists essentially. But these stories should not begin and end in a courtroom. Really, this type of litigation is meant to inspire and support social movements more broadly. So this is just a very beautiful piece of protest art I like from his current campaign. I am Climate Justice, or World Youth for Climate Justice. I'm actually the webmaster of that campaign. So my name again is Robin Happel, and you can feel free to reach out to me. I'm on a variety of social channels. I think with quarantine, we're all very online. So I'm happy to put you in contact with some of our other pro bono law students or attorneys if you're interested in looking at this type of kind of international youth climate case. Additionally, would like focus on some more domestic youth climate cases. So Youth v. Gov, also Juliana v. US is perhaps the most famous in my home country of the United States, but there are so many others around the world. So mine are supposed to be factor in, I already mentioned. Essentially, that was Tony suing on behalf of his own children, saying that by the time that this generation grows up, there will be no more old growth forests in the Philippines. And this, again, you can find a lot of documents on these cases on Informia and other websites, but it was a very, very groundbreaking legal argument in the 90s when he argued this. So he's essentially considered kind of the father of this generation of youth climate lawsuits. And since that time, we've had Greta Thunberg and a number of other students filing a complaint under the Convention on the Rights of the Child. This is a persnickety kind of law thing. It is not a lawsuit, it is a treaty mechanism. So it's a little bit different procedurally. And additionally, there is a challenge with that in that the US is not, which is historically the world's largest emitter, not currently the world's largest emitter, but historically, so is actually not a party to the UN Convention on the Rights of the Child. We're also not a party to CEDAW and some other human rights treaties that could potentially be used for this type of climate mechanism in the future. So that's kind of a historical structural issue with these types of treaty complaints. But nevertheless, this has really gotten a lot of waves and gotten a lot of attention, and it is a very creative kind of legal pathway that I think deserves to be celebrated. Agenda in the Netherlands, that's using very strong human rights language within the EU. If you're interested in legal frameworks in the EU specifically, I am again an American law student, so I'm not quite as familiar with law in the EU. I know one of my law classes earlier this semester, we had a speaker who worked on this case actually, who's very generous with his time and came to talk to us. There are really interesting publicly available documents on human rights in the EU specifically. Additionally, the TCFD and other ESG reporting standards have some free resources on financial reporting in the EU. I've done a little bit of work in the past with climate risk. So one thing that's interesting now as we're having a conversation about how institutions deal with climate is the EU tends to have higher human rights and financial reporting standards than countries like the United States. So there is a little bit of a disconnect between cases like Juliana here being stymied in courts and then cases like Urgenda really being somewhat more successful in some ways. And tutela in Colombia, tutela is basically, I hope I'm pronouncing that correctly, it's essentially a form of a constitutional action, again, addressing deforestation. So you can look up our Children's Trust and other NGOs that have brought a number of these lawsuits around the world. As I mentioned, I think especially for Americans, Juliana is the most famous, but the barriers that Juliana has run into are not necessarily true of all these cases. So I think it's important to remember here that some of the procedural barriers we face in American law in regard to standing, in regard to not recognizing intrinsic rights of nature as much as other countries are unique to us. So the fact that Juliana v. US has run into roadblocks consistently does not mean that this isn't a very viable legal strategy in other parts of the world. And again, I just love this protest artwork. So really, a lot of these cases have caused a much larger conversation in addition to whether they procedurally win or lose. So I think that's really a victory in and of itself. I previously touched on rights of nature. I apologize if this upper right-hand corner gets cut off a bit, but just says rights of nature. And essentially, Portugal, Ecuador, and other countries actually enshrine rights of nature in their constitutions. So this, I think, as an American, it's a little difficult to get your head around because it really bumps up against the property system that's the basis of American law. But essentially, it's saying that nature has intrinsic rights. So as an environmental lawyer, you're not in court on behalf of someone who's been economically or otherwise harmed by a tree being cut down. You're there on behalf of the tree itself. So there was a very famous very famous scholarly document a while ago called Should Trees Have Standing by Christopher Stone, which if you like puns, it's like a lot of law articles and legal professionals love puns. It's just kind of a professional thing. So that's a very cute pun, but also a very fascinating idea. There's various NGOs that work specifically on rights of nature, such as Earth Law Center and also the emerging ecocide movement. So essentially, ecocide is a term for destroying nature and essentially treating that as a crime. And there's been a movement recently to actually add ecocide as a crime to the Rome Statute. So that is a very high procedural bar. And you would need a number of, I believe, 2/3 of countries basically that are parties to that voting to add ecocide as a crime. So it is a very interesting theoretical idea. It kind of remains to be seen whether that procedural bar can be met. But again, being able to actually try ecocide in The Hague would be incredible for environmental law. So it is an emerging kind of consciousness. And I believe that people from the ecocide movement have also met with world leaders like Pope Francis in recent months. So there is kind of that gathering of momentum behind this idea. And additionally, it should be mentioned that this did not originate in the legal community. This idea of nature having intrinsic rights and having rights unbalanced with humanity has been around for really thousands of years among many indigenous communities. So there's numerous examples of this around the world. And I think that bringing rights of nature into the formal legal system is also a way sometimes to recognize indigenous cultural and religious rights that have been sometimes sidelined by many legal systems around the world. Other rights-based approaches. So these are essentially approaches that have not been used as much as youth climate cases, but could potentially become emerging pathways for climate law in coming years. So very briefly, sorry for the brief pause, had to stop to plug my laptop in. It's been kind of a long day on my end. So essentially, other rights-based approaches have not been used in existing climate litigation as much up to this point, but I believe that especially for younger activists, these may be pathways that you see emerge during your lifetime, and many of them are already being explored. So beginning with women's rights, there's been a lot of documentation on how climate change, especially disasters linked to climate change, disproportionately impact women. So there's an NGO called Women's Earth and Climate Action Network that has a great page entitled Why Women. If you want to look up more information, they have a compilation of studies on a bunch of existing scholarship that basically shows that women are disproportionately at risk of becoming climate refugees. They're disproportionately at risk of being displaced in the aftermath of disasters short term. And additionally, within the UN system, there has been the Lima Work Program on Gender under the UNFCCC, and recently, within the past few years, under the Convention to Eliminate Discrimination, all forms of discrimination against women, CEDAW, General Recommendation 37 has incredibly strong language on climate. And although this hasn't been explored as much in the form of a tradition, in the form of a specific treaty complaint like the UN Convention on the Rights of the Child complaint that we talked about earlier, there is a very strong framework within CEDAW of essentially applying transboundary harm concepts to non-state actors, which is somewhere that climate law has tried to go for a long time. So it'll be interesting to see how human rights and climate or environmental litigation may begin to merge in the future. And I believe we're already seeing that with other fields of law as well, that we'll get to later in the presentation. Essentially, also UN Women Watch, there's just so many great resources out there that talk about this link if you're interested. Ecofeminist scholars have also been talking for a long time about the impact of pesticides and other hormonally active chemicals just in drinking water, and there's so much scholarship out there, it's hard to know where to begin. So since this hasn't been formally litigated as much, I am kind of putting it as a sidebar, but that isn't to say this isn't an enormous area of research and work. So if this is something you're interested in pursuing, again, feel free to reach out to me, or again, there's so much you can find in this kind of Zoom online world we're in during quarantine. Additionally, Indigenous rights are an enormous area of work as well. And although I didn't have time to lay this out in this kind of condensed PowerPoint as much, or at least this one text slide, the intersection between Indigenous women and climate is also an enormous area of work. So if you're familiar with the crisis of missing and murdered Indigenous women, MMIW, there's unfortunately been a bunch of, so many studies at the national level in both the United States and Canada that have linked the disappearance and trafficking of Indigenous women to pipeline construction. So if you followed recent protests against Keystone XL and other tar sands pipelines, a lot of what activists on the ground are concerned about is the impact of basically people in man camps coming into their communities and potentially putting women in their communities at risk, which isn't to say that Indigenous men are not at risk as well, but there has been enormous consciousness in the past few years. And if you've seen viral photos online of red dresses hanging from trees, that is a symbol of MMIW as well. In some Indigenous religious traditions, it's believed that spirits can see the color red. So essentially a red dress, which has become really a hallmark of this movement, is trying to bring your deceased friend or family member's spirit back to you. I previously worked on Indigenous sovereignty and climate risk in financial markets with Divestment Best Protect. So although I can't discuss like specific clients or projects I've worked on under attorney confidentiality rules, I think there's a lot of work to be done. And unfortunately, many institutions do not see Indigenous lives, and especially Indigenous women's lives, as really worthy of protecting. So that's a conversation that needs to be had, I think, throughout the legal movement. Very briefly, I know I don't have time to get into tribal law within the kind of confines of this presentation. There's a case a while ago in the United States called Oliphant v. Squamish that essentially said that white men or men who are not of a tribal nation cannot be prosecuted in tribal courts. And that set the stage for essentially decades of crimes against Indigenous women and members of tribal nations within the US going unpunished. And again, the word I'm using on the slide is Indigenous, which points to the UN Declaration on the Rights of Indigenous Peoples. So the term of art varies based on the body of law you're looking at. And for international law, predominantly Indigenous or Indigenous peoples is used in the US. Indian or tribe is used. That's not maybe the words that activists would use to describe themselves today, but it was unfortunately kind of the conception of First Nations and other groups when these laws were written. So again, it really depends on the community you're working with. Climate refugees, this is also an enormous emerging problem in climate law. There are not enough existing protections essentially for people who are displaced by climate events. So typically in international law, you're classified as a refugee if you cross international borders, but this creates a lacuna or gap for people who become IDPs, or internally displaced persons. So for example, in the US, many of our close family friends were displaced by the wildfires in California and they lost their homes, but that isn't considered formally becoming a climate refugee, even if you're in very, very desperate straits after being displaced, because you're still within your own home country. And there was a recent ruling of a man, I believe, who left Kiribati for another country in the Pacific. And essentially, the ruling from the UN in that case was that it was possible to be a climate refugee because you were displaced by climate change, but Kiribati was not sufficiently, like there had not been sufficient climate impacts on Kiribati to make this man specifically a climate refugee. And there's a lot of back from the international law community because Kiribati and other countries across the Pacific are already having very severe climate impacts. So if you're familiar with the SIDS group, Small Island Developing States within the United Nations, or other advocacy groups for Pacific Island states, there's been an enormous, I think, kind of public consciousness raising within the past few years of the impacts that climate is already having. I went to, and I was very fortunate to be a UNA representative for the UN Youth Climate Summit a little while ago. And I remember a speaker from Tonga just really poignantly describing how roughly half his country was flattened in one night and telling us, like, if this was New York, if this was your city, you would act. So I think it's very important to remember that even as people are facing severe climate impacts, not just in the future, but now, there are not always sufficient existing protections. And this is really fascinating to me, just since so many age-based climate suits we see are on behalf of young people. The Union of Swiss Senior Women for Climate Protection v. Swiss Federal Council. I unfortunately cannot say the name of that caption in Swiss. I apologize for that, but that's the translation I've seen. Essentially is arguing on behalf of older women. And we know statistically that older people are more at risk during heat events, which is one of the primary climate impacts we've seen in Europe in recent years. So there is, I think, a real argument here that the elderly are disproportionately at risk in addition to young people, but this isn't really as established a body of law yet. So I think it'll be really interesting to see how that develops. And especially if you're a younger activist watching this, I think this will be a fight that your generation potentially has a chance to really take up, to pursue the pathways on this slide that maybe have not been fully explored yet, but could be in the future. And predominantly, if you look at the Sabine Center's various resources on climate litigation, which you really should because they're an incredible resource, most climate cases in the world today actually are in the United States. So even if you're not from the US, it's worth knowing just a little bit about how US civil law works. And again, because ecocide is not an established crime yet, either internationally or in the US, this is civil law. So basically for monetary penalties instead of criminal. Although there are cases where criminal law could potentially apply to conduct associated with climate impacts. And that gets into piercing the corporate veil and specific suits against corporate officers. And that's probably a little more technical than this presentation needs to be. I don't want to scare anyone off with like corporate law. But essentially, standing is an enormous issue in environmental law cases generally. And the really famous case, if you've taken almost any environmental law course in the US, you've probably heard of this, or even just general constitutional law, is Sierra Club v. Morton. And one really interesting part of this case was it showed that standing can be based on aesthetic harm. So essentially, you can have a right to sue if you're really heartbroken that your landscape is less beautiful now. It doesn't need to be as concrete, like physical or economic harm. Although at the same time, there are typically higher barriers for environmental plaintiffs to bring suits in the US than industrial plaintiffs. And if you read Scalia and other SCOTUS justices who've talked about kind of these types of standing issues over time, one thing you'll see again and again is being subject to regulation is sort of like de facto, like standing is assumed, versus being impacted by regulation in other ways, or arguing that regulation maybe isn't strict enough is typically a little bit of a higher bar. So Laidlaw and Lujan are two other like really major cases if you're interested in environmental standing. You can look up almost any SCOTUS case on a site called OYE, OYEZ. I hope I'm pronouncing that right from my past moot courts. But essentially, Lujan was a really interesting fact pattern, like very convoluted, dealing with endangered species in different countries and like this grant money that the US government was giving for aid projects. And it's sort of convoluted, but essentially that scaled back environmental, like standing for environmental plaintiffs, and then Laidlaw sort of restored standing. Or it expanded kind of the scope of standing for environmental plaintiffs. So currently, in terms of climate law, a lot of these suits are being brought actually by state and local governments in addition to individuals. So traditionally, for a lot of citizen suits in environmental law, you'll see the plaintiffs are individuals or potentially a class or a community group. However, with climate law, we're seeing typically the people who have the resources to bring these suits are larger cities. So Charleston, I believe, was the first city in the American South to bring a climate lawsuit. Baltimore has a standing issue currently going to SCOTUS now, so that'll be exciting to see in their current term how that turns out. That's essentially, I believe, turning on whether climate suits can be heard in state or federal court. So there's different strategic considerations for both plaintiffs and defendants to try to get a suit into state or federal court. And that's, again, like that's more Civ Pro and a little beyond the scope of this presentation. One theory I have heard, which is again a strategic litigation theory, this has not been really totally confirmed, is that a lot of fossil companies want to try to drag these suits out on procedural grounds to avoid getting to the merits. So essentially that's saying like fighting over what court this is in, whether you have standing, these other kind of procedural bars to avoid getting to the stage where, you know, in discovery, it's like, hey, you guys had a bunch of scientific evidence that climate change was real 30 years ago. What did you do? Because that's sort of what they don't want the public to know. So I think that's, again, the value of these suits beyond win or lose, beyond whether you get monetary damages or not, is just raising public awareness of what these companies knew and when. So basically what you'll learn if you take Civ Pro is the discovery process in the US is among the most extensive, if not the most extensive in the world. So the amount of information about like climate science within companies like Exxon that's come from various legal mechanisms is really enormous. And if you've seen like viral hashtags like Exxon knew, that has helped raise public consciousness that one, climate change is real, but two, a lot of these companies knew about it and did not act or did not act sufficiently. And I actually don't remember what company this is, but one kind of really dark example of this is a company actually a long time ago predicted that it would need to raise the level of offshore oil rigs to account for sea level rise. So, you know, if you're going through all these corporate documents, that's about as close to a smoking gun as you're going to get. Clearly, they knew the impacts and really did not do enough to address some of the human rights harms we've already discussed. Again, in my law student opinion, not speaking necessarily on behalf of some of the NGOs I represent, but tort law theories, essentially tort means to twist in Latin. So it's another word for civil law. Before I got to law school, I would have thought like a tort was like a fun little like macadamia nut, like chocolate thing. No, it's civil law. So various claims under tort law are trespass or products liability. So trespass essentially is arguing that sea level rise is a form of trespass. And with these various tort theories, if you're within if you're within like a relatively small circle of causation, then you can be held liable for that type of trespass. Failure to warn and other products liability essentially refers to oil and gas itself. So that's saying that, you know, on an oil pump in the 70s, you should have had a sticker saying like warning may cause climate change, which clearly they did not do because they've actively been suppressing the science for a number of years. And again, this is somewhat beyond the scope of purely litigation, but one thing that's come out in recent years is that a number of fossil companies actually employed the same advertisers as tobacco companies to essentially have a similar corporate strategy of trying to like sow doubt and scientific certainty. So, or near certainty for many climate impacts. So that's another kind of really fascinating historical rabbit hole. If you're interested in that, there's a bunch of publicly available information just on their long-term corporate strategy. And another problem in addition to standing with these suits is causation. So one thing is if you're afraid of trains, maybe don't go to law school because so many of the cases you read 1L are really complicated train accidents. And I honestly don't know why that is exactly. I think it's partly the American legal system was developing alongside industrialization. So this was sort of like a correlation more than causation. But a lot of really banner suits in Civ Pro and tort law are involved, like Erie Railroad, like all these cases have really convoluted like train accident fact patterns. But essentially, there's a case called Paul's Graph that's very famous for proximate cause. And essentially, again, this is like a weird fact pattern. This train conductor was trying to hustle a passenger onto a train. And as he was kind of pushing the passenger, this passenger dropped a packet it was like nondescript newsprint paper, but it contained fireworks. And it essentially exploded under the train, and the shockwaves of that explosion caused a large clock on the platform, like 20 or 30 feet away, to fall on poor Mrs. Palsgraf. And so this is like an incredible thing to have happened ever. I remember reading this case and like, it's just so strange. But the essential takeaway from this weird, wacky series of events is that you're only really liable for something that was predictable and within this certain like zone or scope of causation. And again, that's like not legal terms of art. That's just trying to like simplify this a little bit. So basically proximate cause can be a very difficult barrier for some of these cases, which isn't to say that there isn't a sense of causation between, say, suppressing the science of climate change and having worse hurricanes or other worse climate impacts now. But it's difficult to link specific emissions to specific climate events yet. There is an emerging area called attribution science that sort of seeks to use data science and satellite analysis and other kind of traditional climate science tools to get closer to the point of attribution. I think it'll be interesting to see how that develops. Depending on your interpretation of tort law, causation can be a very high bar. So that is just another procedural issue to flag with some of these cases. Again, a lot of the battle of these cases is public opinion. So it's not to say that you win or lose solely inside a courtroom, but it's just another kind of procedural hurdle to be aware of. And finally, I added a cute picture of this because I know it's a little late in the presentation. I don't want people to zone out as soon as they see securities law. But my personal view is that climate law in the next few years will really merge and kind of begin to overlap with financial law. And the reasons for that are many. One, financial markets are really waking up to climate risk. So we've seen this in New Zealand and other countries that have adopted the TCFD standards as actually mandatory. So essentially TCFD is the Task Force on Climate-Related Financial Disclosures. And there's a great site called TCFD Knowledge Hub, where they basically put a lot of learning resources online for free. So if you're interested in learning more about this and what it is, I think it's a little dry. Like, I'm not going to say like all of securities law is a page turner, but it is really, really important. And this is something you can learn for free if you're interested in it. So essentially, that means that many more companies will be forced to look at climate risk in their supply chains and in their investments. And we're hoping that that functions sort of like cap and trade or these other financial mechanisms to make markets more aware of externalities. And like we discussed human rights earlier in this presentation, kind of more aware of the impact they're having on people, as well as the impact that people have on corporations. So the technical term of art for that is double materiality, which essentially is don't just consider the impact that society has on your bottom line, but consider the impact that your corporation or your organization has in society. And ESG, CSR, other common acronyms you'll see for that. ESG is just environmental social governance. CSR is corporate social responsibility. There's a lot of buzzwords. They're all fairly simple concepts, so don't be intimidated if you see an acronym you don't know. Securities fraud, again, this can be a little bit procedurally difficult. So the really kind of banner securities fraud lawsuit was the New York Attorney General suing Exxon. And that was, if you saw like the hashtag Exxon new trending, it was probably that case. And then Exxon trying to get ahead of that case with a lot of PR. It was an exciting time. One issue that I personally see with these, just having looked at other human rights mechanisms within kind of financial and securities law, is that investors are seen as the victims rather than people who are directly impacted by project finance or some of these pipeline projects. So essentially you're saying, like, if you build this pipeline and it has horrible impacts on local indigenous communities and it pollutes the water supply and it has all these other impacts and it gets shut down because of that, then like, oh no, the investors lost money. And just the first thought that I think a lot of people have, especially career environmental attorneys, is like, is that really like who we're fighting for? But that isn't to say that this isn't a very novel pathway and has, again, unearthed a lot of interesting documents and discovery. So there is infighting within climate law over some of these pathways and especially the framing of them. And I think that will become more sophisticated as more of these lawsuits start to emerge. Tax incentives are another area of financial law that's kind of overlooked. In undergrad, I had the opportunity to go to a conference with a solar trade association, and a lot of the attorneys were actually tax lawyers. And again, that's a very, very technical area of law. Speaking as an environmental law student, which is seen as one of the more technical fields, I remember looking at like geometric means and other like water quality calculations in one of my environmental skills classes earlier this fall. Tax law is maybe one of the only specialties that's more technical than maybe IP law too, but it is a more technical field, but it has an enormous social impact when you talk about tax incentives for solar and EVs. And personally, my family has bought into community solar, and we've had an EV roughly since I was in high school. And we've saved an incredible amount on energy costs and just buying gas over time because of that. So this is something that can really empower communities, especially that have historically been energy burdened. And we know in the US that demographically, people who pay more for electricity tend to have lower incomes and tend to be disproportionately people of color as well. It's a really interesting working paper this past summer that showed that Black families pay more for power than white families, even controlling for income. So I think that's still sort of in the peer review process as far as I know, but that's there's more emerging consciousness of environmental racism and how that affects energy markets in the US just within the past 2 years. So providing basically these incentives for people who may not be able, like my family couldn't, just take a suitcase full of cash and buy an EV. But with some of these incentives and with like a pricing scheme over time that was affordable for us, and it saved us a lot of money. And also I love that car. You can like preheat it in the winter and I love it. But anyways, that's not a legal argument. It's just a very nice car. So I think this is kind of an area of law that does get overlooked, but tax law can also be impactful on climate goals as well. Additionally, UNPRI and other guidelines for investors, which have been adopted by many banks, again in Europe, I believe some in the US as well, have also helped to spur investment and helped to spur people looking at supply chains especially. So that's another issue with carbon and climate risk is people may not necessarily be looking at deforestation and supply chains, even though that's an enormous driver of climate, as we know. So bringing in biodiversity as well as climate, which some UN bodies seek to do, I think will be another really important emerging area of this. And finally, money laundering, which is sort of like what Jack Ryan or Jack Reacher or those guys, like that's their day job. And people kind of think it's like this. I know getting into this, I never really imagined myself looking at money laundering, but that actually does intersect with environmental law in really interesting ways. So there have been a couple white papers the past few years on how money laundering can help fight wildlife trafficking. And one thing that I see emerging is potentially applying that to other types of human rights harms that we discussed earlier in this presentation. So essentially, money laundering or AML compliance, if you want to be technical, can be used to achieve a variety of social goods or further those goals. So a lot of the people fighting human trafficking, fighting, again, wildlife trafficking or like other forms of environmental goods that shouldn't be legally traded have some background in money laundering. So again, it's a very technical area of financial law, but it can have enormous social impacts if you're adept in that field. And finally, I believe that divestment is enormously impactful. I think we've seen that in recent years with Stop the Money Pipeline and other similar campaigns. I've done a little bit of work on that, again, not getting into specific work I've done, and it does have not just impacts on specific projects, but also really kind of raising social consciousness of what is the real cost of what you buy. And again, this is something that the UN has done a lot of work on. When I was an undergrad, I had the opportunity to go to a sustainable fashion show at UN headquarters back before COVID, when we could actually go inside buildings and meet people. And it's just really interesting to think about how, one, your bank or your mortgage lender, or whoever you do business with, has a certain set of values, and ideally you should try to bank with maybe a local credit union or someone who aligns with your values. But also just the clothes we wear, the food we eat, almost everything in our lives really has a story. And if you're familiar with Rainforest Action Network's campaign against palm oil, which they've been doing for a while, then you'll kind of have some awareness of this. But I think it is important just to have really an awareness that an individual can make a difference, which I really do believe. I've been in this field at a very junior level, again, as a student, and many of the supervising attorneys I've worked with have an enormous impact day to day. So if environmental law or any of the other kind of areas of law I've touched on in passing or something that interests you, feel free to reach out to me. And I hope you enjoyed this panda picture and the rest of this presentation. Very briefly, here are some other free virtual resources. This conference I know is a great resource as well. So some of these UN resources are things you probably already know about, but the Environmental Law Institute, and I believe also the Environmental Peacebuilding Association and other groups that work on environmental law have a number of free virtual webinars if you're interested in learning more from really experts in this space who aren't me. Climate Reality Project, again, is a climate reality leader. They've really empowered me. And I think that's just a really strong global network. RSET, if you're interested in the science side of this, which this presentation didn't get into as much, NASA has a bunch of free virtual certifications in basically climate satellites and other sort of technology. I know their Black Marble system that's coming online, I believe around this time, like later this fall or early this winter, maybe, is just really fascinating. They have a lot of really, really cool things coming online. I would encourage you to check that out as well. UNA is free to join if you're under either 25 or 26, I believe. So that's another great resource with Climate Reality for connecting with other like-minded activists. And I believe I already mentioned Informia, but if you're interested in international law, specifically within the UN system, they're a really great resource. So thank you so much for your time, and signing off with, again, a brief bibliography for those who are interested.